some questions already during the break with regard to the first part of my lecture today, and I'm open to any kind of questions, and perhaps we can agree that we start with this tragedy of the commons and anti-commons, and then proceed to whatever you like, a contract law or whatever. Okay?
copper company enters into a collective contract with those 100 people to make it more easy?
Yes, that is possible. That's a good point. Now, that, however, I don't know whether they had this routine that with this collective contract, but this is certainly possible. But I think it would not have helped or have solved the problem, because you have here you have several problems. First of all, the payment in each contract would be different, depending on the distance of the piece of land from the production site. So if it is just in the vicinity, it would be more. If it is 1 kilometer apart, it will be much less, right? So, and then to sort this out is already high transaction cost. And then the problem you have in such contracts is the one which you have also in the problems which lead to taking decisions by the state, that even if they buy it from almost everyone, then you have some people in a holdout position who want to extract all the profit from the other side, you know. That simply, these problems could, as a matter of fact, not be overcome by voluntary transaction. And therefore, in the civil law during the Industrial Revolution underwent, and I'm sorry to say, it had to undergo severe changes, which led to a less good protection of landowners. But otherwise, even though we might have a bad feeling, because they were not all big landowners, but also many small landowners among them, and so from the point of view of justice, we might have mixed feeling about this. But if we had not done this, we might have remained an unindustrial continent in Europe. If you give everybody a veto power. See what I mean?
So why is it that the Ophidian theory of property is ignored in the law and economics literature?
That
Ophidian theory of property.
What Ophelian? What is that?
Ophidian theory of property, sir. So the Ophidian theory of property talks about the differences between rights, freedoms, and power and immunity. These four concepts.
Yeah.
So the differences between these four concepts can reduce the vagueness in the definition of property in economic literature also. So why is it that it is ignored in
that is something to do with doctrinal and consecration.
Yeah, I'm not fully aware of this string of literature, I have to admit.
That is some doctrinal.
Yeah, that's doctrinal, yeah. Mm-hmm. Yes.
Is a fully specified contract of misnomer?
Pardon?
Is a fully specified contract of misnomer? In my sense, from my practice for a couple of years, I've very rarely come across a contract which provides for all possible circumstances, all possible risks. And even the example of Airbus that we discussed, we often hear of Airbus running into disputes with airlines because the delivery of aircraft is delayed and the communication line is extremely late. It's very difficult.
Yes, but in the high value transactions, you have something like that. Usually, in business-to-business transactions, the contracts are actually very precise. No, they are not always very precise. They cannot always be very precise. I come to that tomorrow. But when it comes to allocating risk, they can be very precise, and they allocate the risk to the cheapest cost avoider, and they are also not only very precise but also very long. They have long laundry lists, you know. Such contracts, I have seen recently a contract with regard to the establishment of a shopping mall in Hamburg. Yeah, the contract is 180 pages long, you know. Every detail for instance, in these shopping malls, there is one problem that there are spillover effects from one shop to another shop, which without a shopping mall you cannot internalize, and that's why the shopping malls are becoming more and more popular. So, for instance, if you go to the shopping area in your city, then people want there to have a flower shop, let's say, because it looks nice. They want it, but the flower shop then cannot pay the rent, even though people they enjoy it, or they want a cafe, but the cafe should not cost, you know, 1,000 rupees or what, a cup of coffee or something. And what the shopping malls do in Hamburg, for instance, is they say, look, here, you are a jewelry, you know, you can pay more rent. So we increase your rent, and you agree that the coffee shop pays only a nominal rent. Because the people who go to the coffee shop, they have a coffee, they, at the end of that, they come to your shop and buy your jewelry. So this can all be internalized. All these external effects can be internalized by way of contract, and that's the way how contracts are made. It's not only about risk allocation, but also of risk of internalizing external effects and so on. There are many things, and all this you do not find in, of course, in the law, in the book. So I think the idea of the fully specified contract, which was originally only introduced as a mental game to understand what the law is for, is a pretty good descriptor to understand how contracts work, which are for the long run, for the high transactions, the high transaction value contracts. Yeah. Mm-hmm.
I am not clear with the concept of tragedy of commons and tragedy of anti-commons. So could you please brief out the difference between them?
Well, you know, what commons is, you know, commons is a, let's say, a form of property which, in which many own the property or have rights on the absolute rights on the property. And the most, you know, the most far-reaching property right is the free access with the fishing. That is not a common, but free access. Everybody in the whole world can catch the fishes, has the right to catch the fishes. Now, if we have this commons, I mean, Tragedy of the Commons is the title of a famous article by Hardin, and he says common, but it should read Tragedy of free access. And that leads, you know, this free access leads to an overuse of the resources and to underinvestment into resources, right? Okay, now anti-commons. Anti-commons is a problem when you have concentrated property rights, when you have one owner owns everything. In that case, if you have a resource and if you have an owner who uncompromisingly has all the rights and has them also protected by an injunction, then you get the problem of underuse and underinvestment, because you create for each owner a veto power. You know, if you have this combination of many owners, and each of them has a very strong property right, then you cannot change it. You have hundreds of veto players, and then you cannot change it. And the River Rhine was, I give you the example of the River Rhine. You understand this, you know. There are hundreds of people who all of them own a piece of the River Rhine, and all of them have an injunction. And all of them can, therefore, because they have the injunction, can stop the ships from sailing down the Rhine. And that leads to the underuse of the Rhine and to the underinvestment. So one can say the tragedy of the commons is a particular problem which can arise if we have common property or free access to a resource. Then we get overuse and underinvestment. But the tragedy of the anti-commons, that can happen if we combine a very sharp and very distinct and very, you know, exclusive protection of a property with many property owners. Yes. The Rhine was underused and there was underinvestment of the Rhine. And only when the Rhine was nationalized and we had only one owner, then the efficient solution could be found, and there was enough investment into the Rhine, and the number of total fees for using the Rhine became not did not destroy the traffic, you know, the total traffic. Anti-commons, can you repeat that?
So in the example of Rhine River, before nationalization, suppose there were 200 owners.
Yeah.
So the problem was, though the problem was slightly different, but the root essence was the same, that there were so many number of users or owners. That's why there could not be an efficient use of the river Rhine. So what is then the difference between commons and anti-commons in the terms of number of owners?
Well, if you have few people concerned, right, then you have always the beneficial effect of that, of having lower transaction costs. So for instance, if you have a commons, and if for instance a lawn or a piece of land can be used by the villagers of a village, and if there are only 50 villagers, then this problem of the commons is not so big, because they can easily coordinate, right? And if you have, let's say, a patent user, somebody who wants to use a patent, and if he has to deal with, let's say, 20, 30 people, or it might be more, but with few people, let's say, then the problem of the anti-commons is also not so pronounced. The problems are pronounced in both cases if the number of people with this endowment, with this legal endowment, is high, and if that increases the transaction cost to a prohibitively high level, then you get the tragedy. If transaction costs are low, and they are always low if there are few people concerned, then the problem does not arise to such an extent. Got the point? No? Good.
So in the context of violation of privacy or privacy rights, you said that courts should also avoid disgorgement. My question is, what is the basis of avoiding punitive damages also? Like for instance, in the Harry case, we saw that lawmakers had to pay 100 million plus punitive damages. So this was much more than the profit that there is no disgorgement profit here. So this is an increasingly popular way of settling such cases, deciding such cases. So this is what we look at. How do you look at that?
Well, I think we have a session on tort law also, and punitive damages are especially prominent in tort law, and I'm a bit reluctant to comment on punitive damages right now, because they are related to a different problem. They are not related to this problem of anti-commons and commons, but they are more related to the cure shortcomings of law enforcement. So if there is a law enforcement error that can be cured by punitive damages, this is one problem which, however, I would have to elaborate, and another problem which I also would have to be elaborate. In the United States, punitive damages are widespread, but on the European continent not, and in Germany they are even unconstitutional. They cannot be used for good reasons, I think. So, for instance, if we have a bilateral agreement between Germany and the United States for executing court orders, you know, a German court order, if the defendant lives in the USA, is then enforced by American authorities in the USA and vice versa. But if the American court order includes punitive damages, then the agency which is in charge of that does not even send the court order to the defendant, because it is unconstitutional, and it's certainly not enforced in Germany. But you know, this is a somewhat difficult and different problem. Yes.
changes on the exterior, then what action that owner will take and against.
Ah, that's good. Well, I hope you have all understood the question. You know, there is a house owner who leases the house to a tenant, but under the condition that he cannot change the house, right? And the tenant then leases it to the subtenant, but without this clause. Then, well, the first question is whether the house owner has an entitlement from being the owner. And I don't think he has. So if he has, from his absolute right as an owner, because if he has agreed with the tenant, and if he has perhaps agreed that the tenant makes a subcontract, then he might have only a right to damage compensation against his tenant. So the subtenant could say, well, you know, I acted in good faith. I did exactly what was in the contract. The contract did not say anything about not changing anything, so I did the changes which are usually, you know, which are usual perhaps. Then I would say that the house owner cannot claim anything from the subtenant, but he must get everything from the tenant.
So in that case, you will take the action only of the damage compensation, or like you might consider this as breach of contract and cancel the contract?
Well, he is entitled to damage compensation and to might be, if restitution is possible, to restitution. He could say, well, you know, I want it back in the same in the same state as it was when I rented it out to you on this condition that it is not changed, and therefore I think he must get whatever he can get, that is restitution of the previous state or damage compensation from the tenant, but not from the subtenant. Of course, I mean, if the subtenant did changes which are totally out of proportion, then still the property right would work. More questions? We still have 10 minutes time.
So you said that lawyers do not have a consequential history of contracts.
Just raise your hand.
You
Yeah.
said that lawyers do not have a consequential history of contracts. Don't you think that's the right approach for lawyers? I mean, we are aiming that we do not decide the substantive terms of a contract. We are going to ensure that the contract is compliant, law compliant, and enforceable. Shouldn't they maintain some sort of distance from? Why should they judge defects of a contract? It's not with the paper.
Yeah, I agree with that, that the lawyers, of course, they are well aware that the contract is something which the parties, which helps the parties to fulfill their goals, you know, and that the contract is instrumental to this. I think that is not the point, but that is also not the problem. That there is a difference between how economists and social scientists in general look at contract law and at law in general, And the the economist's view is really a very, very distinctly consequentialist view. And the lawyer, let's say the doctrinal lawyers, they would not deny it. But when it comes to the hard arguments in a case, for instance, or in a general political arena, then they argue doctrinal, and doctrinal, almost by definition, is always non-consequential. Yeah. Unfortunately, this is still so, but it is changing. I've a bit exaggerated, I think.
But sir, nowadays even a big company or a company
Yeah.
are not the two party who indulge in contact. So
Mm.
the law department or law sides who deals with the contract
Yes.
or the contract should be fair.
Mm.
In that scenario, those lawyers who are involved in the contract making
Mm.
should comply with this comprehensive terms.
Yeah. Yes, I mean, I would agree with what you say. Yeah, yeah. Yeah. Well, yeah.
So in the case of Manchester copper mill,
Yes.
so what can be the voluntary and involuntary action with respect to factory or mill?
With respect to,
So what the voluntary and involuntary steps the mill can take?
you mean after or before the court decision? Before. Yeah, well, the mill could, in principle, offer all landowner a servitude. You know what a servitude is? No, a servitude is an entitlement of somebody else to use your land, to use your land for a particular purpose. For instance, there are servitudes which say that, well, for instance, the land, you can use the garden, not as a lease, not as a contract, but then it gives you a property, a right, an absolute right to use the garden, not a relative right. And in the same way, they could say that a servitude is now an absolute right of the copper mill to inflict damages, that is here noise, I think it was noise in the first place, to inflict noise on that piece of land. That is a servitude. Yeah. Sure. We have still some minutes to go, but yeah.
And you said that the reservation price is the lowest price at which producer will sell.
Yeah.
Will there be a reservation price for the consumer as well?
No, the consumer will buy the good if it is assume the price is zero or even negative, then the consumer will always buy. For the consumer, the equivalent of the reservation price is the willingness to pay. So the utility which the product gives him. Yeah.
So in that Rhine-River example, what would happen if those 1,000 people
Mm.
would have been settled by the government itself?
Those 1,000 people would have been,
I mean, those land rights or the sea rights,
yeah.
sorry, the river rights would have been given by the government.
Well, I don't fully understand this. The government, previously, there was no government in that sense, you know. There were only these barons, and they had certain property right, which was not like private property. So the barons always also fulfilled some public purposes, and therefore a state as we know it today did not exist at the time. But so what do you mean? Then the
I mean, for the suppose there is a river in the present scenario,
yeah,
and some people reside by it, and which is causing a lack of efficiency and investment.
yeah.
The traders can't move around. But it's the only occupation for them. So the government has asked them to stay there. So what happened in the situation? Because it is helping a few sections of people.
Yeah, well, I'm not fully informed in this case with the you know, how that actually happened. But I think that during the French Revolution, that was during the French Revolution when the Rhine was French. Then they nationalized the Rhine, and they were quite, these revolutionaries, they were not very fond of paying compensation. And given that the landowners were not, most of them were not small farmers, but barons, you know, big landowners, I would be surprised if they had paid them anything. But it could be. I don't know. Yeah.
Efficiency only the consideration when deciding between both of law. Most efficient solutions
Mm.
will be just
Mm-hmm.
access to a lot of people. Like in the case of Odisha, when Costco was coming in, it is trying to displace the tribal people out. Might be good for the efficiency, the economy might be good, but the tribal people would get displaced completely out of it in the procedure. Should efficiency always be the consideration when deciding how law or certain course of action is taken?
No, I don't push that principle so far. Now, for instance, especially if we have, when it comes to human rights, for instance, then we have sometimes human rights, or often human rights trumping efficiency consideration, right? So, for instance, if somebody could, without reasonable doubt, prove that slavery is better, is more efficient economically and would lead to a higher per capita income than non-slavery, that would still be unconstitutional. You see, that is a simple example. But, you know, we are here in the sphere of civil law, that is basically contract and property. And I think that in civil law, in private law, and that is the law regulating markets, that there the efficiency considerations are very important. You see? That does not mean that efficiency is the leading concept in law. I would not go so far. But it is an important one, and often it is often the best thing to solve social problems with transfer payments to the affected, rather than with cutting into markets and, you know, at the big cost of efficiency. There is a study of the World Bank which just gives you one example. In Canada, they introduced import duties in the textile industry. Huge import duties in the textile industry to protect job market, to protect workers in the textile industry. And this law has saved, I think, 1,000 workplaces in Canada in the textile industry. So otherwise these jobs would not exist anymore, and one does not know whether all these people would have got other jobs. But somebody calculated from the World Bank that this cutting into the contract, to the freedom of contract by these high import duties, led to efficiency losses which are in a relation of 70 to 1 to the gains for the affected. So, you know, $1 which the affected, these 1,000 people get, costs $70 in terms of efficiency losses. And this grotesque mismatch between efficiency losses and, let's say, gains of justice or of social justice, that should be reduced. And you can reduce them better if in those spheres of the law, like contracts and property and to some extent tort, you don't overload this with social justice consideration without ever leaving the concept of social justice out of the game. I'm very much with you when you say we have to take other considerations into account, not only efficiency, that is for me quite sure, but we also have to look which are the fields of law in which we can reach this best. And then it comes to constitutional law, protect property rights well, and it comes to welfare law, social welfare law, that is, do not create losers from whatever reasons. But simply to cut into freedom of contract, for instance, has often very high welfare losses, which are out of proportion to the justice gains they often gain. Well, time is over. We have to conclude, so thank you very much.